Hi guys, it's Kathy. I hope you're doing well. I realized yesterday when I ended the stream that it would be a mistake if we're gonna delve into Australian court. It would be a mistake to skip over Erin Patterson, the mushroom lady. Um, huge, huge case in Australia, not too long ago. It was fairly recently. I'm not going to tell you about it. You're going to hear all about it. We have the sentencing. So we don't get to see Erin. Just like the UK sentencing, it's just the camera and the judge. That's it. But you can hear her sometimes in the background. Or he'll tell her things like, stand up, sit down, and you can hear noise. So that's what we're watching. It's a wickedly weird story. So, and the way he tells it, so proper and pompous, and it makes it worse. Here we go.
Erin Patterson, after a long trial, during which you gave evidence that the poisoning of your 4 lunch guests...
Okay. I'm going to pop on another video really quick for you to enjoy while I make this even louder, which will make it better. I promise. I promise. Don't worry. We got plenty of videos to watch while I make this louder. Oh, I didn't do this one yet? Oh, jeez. Okay.
By Gary Garman.
Morning.
Morning, sir. Morning, Mr. Worthley.
Good morning, Judge. I was delayed because I was reviewing the addendum to the notice of violation of pretrial release with Mr. Garner, and he explained to me that he had been detained in another state. And so I was trying to pull up the Wisconsin records, but I think I just found them. And just show Mr. Garman. I believe what Mr. Garner had explained to me was that there was a possession of marijuana case in Wisconsin from about 2022 that he had incorrectly thought that that case had been resolved years before. And when we released him from Porter County Jail, there was no information about a warrant that was pending in Kenosha, Wisconsin. He discovered it shortly after leaving the Porter County Jail, which he was released on our case about approximately early December. He discovered the issue in Kenosha, Wisconsin, and then traveled up there and was in the Kenosha jail for both of the dates that are referenced on the notice of violation of pretrial release. So I have advised him of the allegations of the violation. We would enter a denial and ask the court, go ahead, here. Ask the court to take that under advisement, and we can hopefully resolve it through the resolution of the case in chief.
State. Judge, if I may remain seated for just a moment. I'm just looking at the history of the case in my file. It shows the defendant failed to appear in November of 2024. Ultimately, he was released in December. No, I'm sorry. I'm going to go back further. Looks like his first failure to appear was in October of 2024. A warrant was issued. Then there was an attorney status on November 15th. Failed to appear for that as well. He was released. It looks like there was a notice of pretrial release violation filed in April of 2025. And then again, we're looking at the new petition and the addendum And now there's been a warrant issued. And again, Judge, I'm going to ask that he be taken into custody. I think there are phones in jails, and no effort apparently has been made to contact his lawyer, the probation office, or the court.
And when I look back at this, I see what you're saying. Well, this case came back as a redocketed diversion, correct?
Yes.
It's never good when he's thinking this hard. Never. Yo, they gave me some burnt something as coffee this morning. It's really
Trial
bad.
released back in September
Bad.
2024. Failure to appear back in November 2024.
Yo, my chat room again is full of
Three trial release
injury and
violations
illness.
in April 2025.
Guys, I'm so sorry. Everybody's feeling so bad and injured so hard. I feel so bad for you guys. Listen, just watch some court. What's about to happen in the next 30 seconds will make you feel better.
And then the instant pretrial release violation. So yeah, I'll maintain our warrant, take Mr. Garner into custody.
Excuse me, I was locked up, sir. Please don't do this. I have a family and I have bills to pay. Please.
Mr. Garner, I need to keep you in this jurisdiction until we can dispose of this case.
Excuse me, I have to go to court. Please, please, please. I have court next week, please. And
Sir, I
have to pay
made my
bills.
ruling. We'll take you into custody. And what's the best time for a court date, Mr. Worthley?
Please, please, Judge Fish, please. Please, Judge Fish. I have 3 kids that need me and I have to work to pay the bills. I only missed court because I was in custody. I never.
March 13th?
Yes, Judge.
Please, Mark.
Okay. We'll have you back on March 13th. We'll do it at 10.
I have court at March 13th. I have court on March 4th and March 13th. If I can't keep missing court, they're going to keep issuing warrants, officer.
Oh, I understand, sir. I understand. That's your situation here.
Please don't do this. Please don't do this. Please.
We'll see you back on March the 13th, sir. 10
I
o'clock.
didn't do anything.
10 o'clock?
Yes.
Can I give her a
Look pretty
kiss?
solid at 9.
Can I give her a kiss, Judge Fish?
No. You can give her the keys. I thought you said a kiss.
He did say a kiss.
I apologize. Keys, yes. A
Judge Fish,
kiss,
I was
no.
in custody every time. I'm not a bad person. Please, can you please?
No one is saying you're a bad person, Mr. Garner, but I need to keep you in this jurisdiction until we can resolve this case. We're adjourned.
He said kiss. I heard it. Judge heard it. Everybody heard it. Okay, this is better, guys. Sorry for the detour, but it was a lovely detour. I love Judge Fish. Now, back to Australia.
Erin Patterson,
Better.
after a long trial, during which you gave evidence that the poisoning of your 4 lunch guests on the 29th of July was an accident, the jury found you guilty of 3 counts of murder and 1 count of attempted murder. In other words, the jury necessarily found that you deliberately served poison meals to Gail and Don Patterson and Heather and Ian Wilkinson, and that you did so intending to kill them. Only Ian Wilkinson survived. The maximum penalty for murder is life imprisonment, and for attempted murder, 25 years imprisonment. Murder is also a standard sentence offence, and the standard sentence offence for murder is 25 years imprisonment. The prosecution submits and your counsel concedes that your offending falls into the worst category of offending for these offences and that you should receive the maximum penalties for your crimes.
Except, Judge, I would like to suggest that you're misremembering what you're reading. Not even Sue could get her out of this one.
I agree, for reasons that I will come to in due course. The prosecution also submits that, having regard to the horrendous nature of your crimes, I should not fix a non-parole period. In other words, the prosecution submits that you should never have the opportunity of being released from prison on parole. Your counsel challenged this submission, relying principally on the harsher than usual conditions of your imprisonment, which both sides agree are likely to continue for the foreseeable future. Whether or not to fix a non-parole period is the main dispute which I have to determine. These sentencing reasons consist of 4 parts. First, the circumstances of the offences. Second, your circumstances. Third, relevant sentencing law. And fourth, the actual sentences. It is convenient at this stage to mention one aspect of sentencing law. Where the prosecution alleges circumstances that aggravate your offending, the prosecution must prove those circumstances beyond reasonable doubt. Where the defence alleges circumstances of mitigation, the defence must prove those circumstances on the balance of probabilities. Just before I turn to the circumstances of your offences, I note that at your trial the prosecution conceded that they could not prove motive. As is standard, I directed the jury that the prosecution did not have to prove motive, only the elements of the offences, and that, quote, some murders occur for no apparent reason. The motives for such murders may only ever be known to the offenders. Clearly, the jury was satisfied beyond reasonable doubt that you committed the alleged offences. Only you know why you committed them. I will not be speculating about that matter. I will begin my discussion of the circumstances of your offences with the fact that you were familiar with the iNaturalist website from at least May 2022. That is a website on which people can post and view sightings of death cap mushrooms, amongst other things. On the 28th of May 22, you accessed the iNaturalist website and navigated to its worldwide map in relation to sightings of death cap mushrooms. Using that map, you accessed information concerning the sighting of death cap mushrooms in Moorabbin, a suburb of Melbourne. In late 22, a dispute arose between you and your estranged husband, Simon Patterson, regarding child support payments for your 2 young children who live with you. In December 22, you referred to that dispute in your communications with a Facebook Messenger group with whom you shared an interest in true crime. You were scathing in your remarks about both Simon and his parents, Don and Gail Patterson. Amongst other things, you derided your father-in-law's suggestion that you and Simon get together and pray for your children, commenting, quote, this family, I swear to fucking God. You called them, quote, a lost cause. You wondered whether they had, quote, any capacity for self-reflection at all. You said, quote, fuck 'em, and that you suspected the best thing you could do was, quote, just to forget about all of them and live your life. You accused Simon of, quote, gaslighting you, and Don and Gail of using, quote, weasel words. You called Simon, quote, a deadbeat, and wondered why Gail was not, quote, horrified by his stance regarding child support. According to your testimony at trial, and to a lesser extent Simon's testimony, the dispute over child support had resolved by early 23. On the 18th of April 23, one Christine McKenzie, a former poison specialist, was visiting her daughter in Lock, which is a small town about a 25-minute drive northwest of Leongatha, where you lived. Miss Mackenzie observed death cap mushrooms in Loch Reserve and posted details of her observations, including photographs, on the iNaturalist's website the same day. Ms Mackenzie disposed of all the death cap mushrooms that she could find because of the danger she thought they posed, especially to young children. On the morning of the 28th of April 23, your mobile phone, which was never recovered by investigators, connected to certain cell towers consistent with a possible visit by you to the Loch Reserve. That afternoon, you purchased a food dehydrator in Leongatha. Between the 28th of April and the 4th of May 23, you photographed forage mushrooms on the trays of your dehydrator. The images were found by investigators on a Samsung tablet later seized from your home. Dr. Tom May, a world-renowned expert in fungi, gave evidence at your trial that those images were, quote, consistent with death cap mushrooms to a high degree of confidence. On the 21st of May 23, Dr. May observed death cap mushrooms in Nielsen Street, Outram. Outram is a small town about a 23-minute drive southwest of Leongatha. Later that day, Dr. May posted details of his observations, including photographs, on the iNaturalist website. On the morning of the 22nd of May 23, your phone connected to certain cell towers, consistent with a possible visit by you to Loch Reserve. Later that morning, your phone connected to certain cell towers, consistent with a possible visit by you to Nielsen Street, Outram. On the 24th of June 23, you hosted a lunch at your Leongatha home, attended by Don and Gail and your children. You had invited Simon to that lunch, but he declined, saying in a text message, quote, "Hi Erin, thank you for your kind lunch invite, together with Mum and Dad. I'm sorry, I'll decline, as I feel too uncomfortable about it." Between the 28th of June and the 7th of July 23, there were a series of messages between you and Gail in which you falsely represented that you had undergone a needle biopsy for a lump in your arm and an MRI. In response to a message from Gail as to how you got on with your medical test, you messaged her on the 7th of July 23 that, quote, "There's a bit to digest with everything that's come out of it all. I might talk more about it with you both when I see you in person." On the 16th of July 23, you attended the Sunday service at the Corumburra Baptist Church, where Ian Wilkinson was and is the pastor. After the service, you invited Gail and Don Patterson and Heather and Ian Wilkinson to lunch at your home at Gibson Street, Leongatha, on the 29th of July 23. Both the Pattersons and the Wilkinsons were surprised by the invitation, as the Wilkinsons had never previously been invited to a meal at your home. You also invited Simon, telling him that you had invited his parents and his aunt and uncle. You told him you had some important medical news which you wanted to discuss at the lunch, and that you did not want the children to be present. Simon initially accepted your invitation and informed his parents that the purpose of the lunch was to discuss your medical issues and how to inform the children. On the evening of the 28th of July 23, Simon and you exchanged messages. Simon's read, quote, "Sorry, I feel too uncomfortable about coming to the lunch with you, Mum, Dad, Heather and Ian tomorrow. But I am happy to talk about your health and implications of that at another time if you'd like to discuss on the phone. Just let me know." You replied 5 minutes later, quote, "That's really disappointing. I've spent many hours this week preparing lunch for tomorrow, which has been exhausting in light of the issues I'm facing, and spent a small fortune on beef eye fillet to make beef Wellingtons, because I wanted it to be a special meal, as I may not be able to host a lunch like this again for some time. It's important to me that you're all there tomorrow and that I can have the conversations that I need to have. I hope you'll change your mind. Your parents and Heather and Ian are coming at 12:30. I hope to see you there." On Saturday the 29th of July 23, you served your 4 lunch guests individual beef Wellingtons, which were deliberately poisoned with death cap mushrooms. You gave evidence at your trial that had Simon attended the lunch, you would also have served him a beef Wellington. I accept the evidence of Ian Wilkinson that you served your guests their meals on 4 grey plates, while your individual beef Wellington was on a smaller orangey tan coloured plate, a fact that Heather also commented on to Ian and Simon the next day. I find that you did this to ensure that you did not mistakenly consume a poisoned meal. I also accept the evidence of Ian Wilkinson that at the conclusion of the meal, you falsely told your guests that you had been diagnosed with cancer and sought their advice as to whether and how you should break the news to your children that you had a life-threatening illness. Not long after this conversation started, your son and his friend, who had gone to a movie, returned home. The conversation about cancer ceased, but not before all your lunch guests, at Ian's suggestion, prayed for your health. Soon after, they left. Around midnight to 1 a.m. on Sunday the 30th of July 23, all of your lunch guests fell seriously ill, suffering repeated vomiting and diarrhoea. On Sunday morning, Gail and Don informed Simon of their conditions and called an ambulance which took them to nearby Corumburra Hospital. Simon attended the Wilkinsons' home to find that Heather and Ian were similarly unwell. He took them first to Corumburra Hospital but was redirected to Leongatha Hospital because of limited resources. By way of contrast, you made a round trip of approximately 2 hours on Sunday afternoon to take your son to a flying lesson at Tyabb. By the Sunday evening, Don and Gail had been
Flying lesson? Does he mean airplane? Or is that something else? Because is this kid or her kids old enough to have flying lessons? I just didn't understand that part.
transferred to Dandenong Hospital. On the morning of Monday the 31st of July 23, Ian and Heather were also transferred to Dandenong Hospital. Later that day, Gail and Don were transferred to the Austin Hospital, as were Heather and Ian on Tuesday the 1st of August 23. All of them were experiencing advanced multiple organ failure. Having learned from Simon on the Sunday that your parents-in-law had been hospitalised, you attended Leongatha Hospital on the Monday, complaining of diarrhoea. You did not stay long. Shortly after a doctor indicated to you that death cap mushroom poisoning was suspected, you left, despite warnings by another doctor and nurse that your life was in danger. You returned over an hour and a half later. When you returned, you showed reluctance to receive treatment for suspected death cap mushroom poisoning and to organise a medical assessment for your children who were at school. Medical staff were urging you to have the children assessed because you claimed, falsely, that on the Sunday night you fed them the leftovers of the beef Wellingtons with the pastry and mushrooms scraped off. Eventually, you arranged with Simon to collect the children and bring them to hospital. On the Monday morning, police recovered beef Wellington remains from a bin outside your home, which were later found to contain death cap mushroom toxins. On the Monday afternoon, you were transferred to Monash Medical Centre in Clayton. Simon brought the children there. You and the children were kept in hospital overnight for observation. At both Leongatha Hospital and Monash Medical Centre, you were asked by various people, including doctors and representatives of the Health Department and the Child Protection Service, where you had sourced the mushrooms for the beef Wellingtons. You said you had purchased some fresh mushrooms at Woolworths and some dried mushrooms from an Asian grocery. You were vague about the location of the Asian grocery, claiming you had purchased the dried mushrooms several months before and that the shop could have been in one of a number of suburbs that fall within the boundaries of the city of Monash. You denied having foraged for mushrooms, a lie repeated in your recorded police interview on the 5th of August 23. At your trial, you maintained the story about having sourced some of the mushrooms from an Asian grocery, but testified that in May and June of 23, you had foraged for edible mushrooms in various places, including the Corumburra Botanical Gardens. You testified that you had dehydrated these mushrooms and put them in a container which contained the dried mushrooms from the Asian grocery, and that you used the dried mushrooms in that container along with the fresh mushrooms from Woolworths in the beef Wellingtons. You testified that in this way, death cap mushrooms must have accidentally found their way into the meals served to your lunch guests. The jury rejected this elaborate explanation. They found that you deliberately poisoned the meals of your lunch guests. I am satisfied that your vague story about the Asian grocery was a lie. When you realised that the lie would not work because death cap mushrooms cannot be cultivated commercially, and there were no other reports of people falling ill from mushrooms purchased at Asian groceries, you changed tack. You concocted the story you told the jury about foraged mushrooms ending up in the container with the Asian grocery mushrooms and then accidentally ending up in the beef Wellingtons. On the afternoon of Tuesday the 1st of August 23, you and the children were discharged from Monash Hospital. On the morning of the 2nd of August 23, you disposed of your dehydrator at a local tip, the Coonawarra transfer station. On the 4th of August 23, investigators recovered your dehydrator from the tip. Forensic examination revealed that the dehydrator contained traces of death cap mushrooms. That same day, 4th of August 23, Heather Wilkinson, aged 66, and Gail Patterson, aged 70, died from death cap mushroom poisoning. And Don Patterson, who was desperately ill, was given a liver transplant. On the 5th of August 23, the police executed a search warrant at your home. You handed over a dummy phone. It was not the phone that you had been using throughout most of 23. The phone which on the 28th of April 23 had connected to certain cell towers indicating a possible visit to Lock, and which on the 22nd of May 23 had connected to certain cell towers indicating possible visits to Lock and Outram. In your recorded interview following the search, you denied having foraged for mushrooms and denied owning a dehydrator. Late on the 5th of August 23, Don Patterson, aged 70, died from death cap mushroom poisoning. Ian Wilkinson very nearly died, but gradually his condition improved. On the 21st of August 23, he was discharged from the intensive care unit to a ward at the Austin Hospital. On the 11th of September 23, he was moved to the Heidelberg Repatriation Hospital. On the 21st of September 23, he was discharged home. He has not fully recovered. He has reduced kidney function, ongoing respiratory issues and reduced energy. On the 2nd of November 23, the police executed another search warrant at your home, seizing more electrical devices. You were arrested and charged. You have been in custody ever since. Let me now summarise the aggravating circumstances of your offending. Your offending, which resulted in the death of 3 people and near death of another, involved substantial premeditation. I am satisfied that by the 16th of July 23, when you unusually invited Simon, his parents and his aunt and uncle to a lunch without the children to discuss your non-existent medical issues, you did so with the intention of killing them all. The dehydrator, which you purchased in late April 23, enabled you to preserve death cap mushrooms, which you put into the individual beef Wellingtons served to your guests. Whether those death cap mushrooms came from Lock on the 28th of April 23, or from Lock or Outram on the 22nd of May 23, or from another location in May or June of 23, as you suggested in your testimony, is in my view of no great moment. After learning from Simon on Sunday the 30th of July 23 that some or all of your lunch guests had been hospitalised, you showed no pity for your victims. Instead of informing those treating the Pattersons and Wilkinsons that you had used foraged mushrooms, which you could have done without having to admit that you had deliberately poisoned their meals, you repeatedly denied foraging, insisting that the mushrooms for the beef Wellingtons were sourced solely from Woolworths and an Asian grocery. We will never know whether revealing the use of foraged mushrooms would have made a difference. But the administration of the drug psilocybin, which is a specific antidote for death cap mushroom poisoning, was not commenced on the 30th of July 23 because at that stage the evidence regarding the type of toxin was inconclusive. Similarly, the administration of NAC to preserve the victims' livers from toxins was not commenced until almost midnight on the 30th of July 23 for Don Patterson and on the 31st of July 23 for the others. The prosecution submitted that I should infer from your pitiless behaviour that your intention to kill was ongoing and that this constitutes an additional aggravating circumstance. I accept that submission. As the Wilkinsons' daughter, Ruth Dubois, remarked in her victim impact statement, you, quote, followed through on your lethal plan. Your lunch guests each suffered severe gastrointestinal illness on the Sunday and Monday prior to being sedated and mechanically ventilated. Their suffering was protracted. And Ian Wilkins suffers ongoing health issues. This aggravates your offending. The prosecution submitted that you must have anticipated that your victims would suffer in the way they did. I am satisfied of that beyond reasonable doubt. It is implausible that you would have selected death cap mushrooms without ascertaining how they would work upon your victims. Further, the devastating impact of your crimes is not limited to your direct victims. Your crimes have harmed a great many people. I will expand on this aggravating circumstance when I turn to the victim impact statements. In addition to denying the use of foraged mushrooms, you engaged in an elaborate cover-up of your guilt. I find that you disposed of the 4 grey plates on which you served the poisoned beef Wellingtons. You falsely made out that you had fed your children leftover beef Wellingtons with the pastry and mushrooms scraped off. You feigned illness. You disposed of the dehydrator soon after you were released from hospital. You maintained the vague story about sourcing dried mushrooms at an Asian grocery and had the gall to tell police in your recorded police interview that you had been very, very helpful to the health department in its investigation of the incident. You disposed of your phone and provided police with a dummy phone. You lied to the police in your recorded police interview about various matters. Finally, and most importantly, your offending involved an enormous betrayal of trust. Your victims were all your relatives by marriage. More than that, they had all been good to you and your children over many years, as you acknowledged in your testimony. Not only did you cut short 3 lives and cause lasting damage to Ian Wilkinson's health, thereby devastating the extended Patterson and Wilkinson families, you inflicted untold suffering on your own children, whom you robbed of their beloved grandparents. The victim impact statements reveal the immense and ongoing anguish suffered by your many victims, direct and indirect. No summary could do justice to the individual and collective power of those statements. It is not my intention here to summarise or refer to every statement, but rather to highlight some key aspects. 4 generations of the extended Patterson and Wilkinson families have been traumatised by your crimes, not to mention their friends. Don's mother, Martha Patterson, who is aged 100, made a victim impact statement. In it, she prayed for God's healing for her family. Gail and Heather's father, now deceased, also reached his 100th birthday in 2024, but tragically only one of his 3 daughters, Lynn Young, whose statement was read to the court, was alive to mark that milestone with him. And there are many references in the statements to the trauma experienced by the Patterson and Wilkinson grandchildren. Many of your adult victims struggled not only with the loss of their loved ones and the terrible way they died, but with the distress, even guilt, at their own seeming inability to ease the suffering of those close to them. They keenly feel their limitations, and in particular, the impossibility of shielding the youngest from the incessant discussion of the case in the media, online, in public spaces, even in the schoolyard. Many also struggled to cope with work and studies, and many have experienced additional financial burdens. There is, of course, great anger at the callousness of your actions. To take just one example, Ian Wilkinson's sister, Dorothy Dicker, questions, quote, how anyone could sit there and watch those four kind and caring people eat that meal. Your failure to exhibit any remorse pours salt into all the victims' wounds. The children of your direct victims speak of the distress of watching their parents suffer in hospital. For example, Don and Gail's son Matthew remarks, quote, watching my parents suffer in hospital from severe poisoning caused shock, grief and lasting trauma. Ian and Heather's son David remembers his mother being, quote, desperate for water, which she was not allowed by medical staff, and saying her, quote, insides were burning. David also mentions his father's tortured experience, quote, black lips, gaunt face, pained and serious expression. At your plea hearing, Ian Wilkinson memorably read his victim impact statement to the court. Amongst other things, he humbly expressed his great admiration and love for his wife, Heather, and his concern for others, even you. He offered you forgiveness for what you did to him. Quote, in regards to the many harms done to me, I make an offer of forgiveness to Erin. I say harms done to me advisedly. I have no power or responsibility to forgive harms done to others. However, I encourage Erin to receive my offer of forgiveness for those harms done to me with full confession and repentance. I bear her no ill will. That offer of forgiveness presents you with an opportunity. You would do well to embrace it in the manner he suggests. In commenting on the unprecedented coverage of your case, Ian Wilkinson also made this point, quote, it's one of the distressing shortcomings of our society that so much attention is showered on those who do evil and so little on those who do good. Your lunch guests undoubtedly belong to that company of people among us who do good. The victim impact statements make it clear that each one of them, over many years, gave of themselves generously and made lasting contributions to many, many lives, and in Ian's case continues to make. All of them.
See, Brent, if we were close together, I wouldn't complain about what you just said. I wouldn't complain about it at all. I would just get a knife and stab you.
Inspired by their Christian faith, were deeply invested not only in their families but in their wider communities, as the statements from members of the Currumborough Baptist Church attest. A word that is used again and again in the statements to describe your crimes is, quote, senseless. But what also surfaces in the statements is hope and gratitude for the care shown by others. Don and Gail's daughter, Anna Terrington, writes, quote, we have to say goodbye for now to Mum and Dad and Heather. Don's brother Colin writes, quote, as Christians they were people of hope, and sharing that hope, my loss is not one marked by despair. Ruth Dubois expresses her great appreciation for the efforts made and compassion shown by the medical teams. Simon Patterson gives thanks, quote, for the incredibly strong, gentle, patient and caring support from friends, family, schools, our own church congregation, the wider church, colleagues, work clients, neighbours, police, government officers and our professional counsellors. We have experienced love in a special way since the murders. I will conclude my account of key aspects of the victim impact statements with what Don and Gail's son Matthew had to say about your betrayal of trust. Quote, Erin was embraced as part of the Patterson family. She was welcomed and treated with genuine love and respect in a way she did not appear to experience from her own family. Her actions represent a profound and devastating betrayal of the trust and love extended to her. Having regard to the aggravating circumstances of your offending and the victim impact statements, I have no hesitation in finding that your offending falls into the worst category for the offences of murder and attempted murder. As the case law makes clear, the fact that it is possible to imagine even worse instances of such offences does not refute that categorisation. The gravity of your offending warrants the imposition of the maximum penalties for your crimes. I turn then to your circumstances. The information I was provided about your personal history was minimal.
Her circumstances. Let's just look at what we heard so far. I'm sorry, I'm talking again. I apologize. I'm sorry. She's taking her kid to a flying lesson. She's serving beef Wellington. Her circumstances are extremely comfortable, I would say. I would say even more than that. Maybe flying is like soccer over there and it's not as expensive as I think it might be. But in my head, flying lessons here, what is it, like $8,000 to get flying lessons? That's a lot. And beef Wellingtons, I've never even eaten one. I've never eaten a beef Wellington, ever. I don't even know if I've actually seen one in person, a real beef Wellington in any of the restaurants. So her circumstances. She was complaining about child support. We are all rich here. Let's hear about her circumstances. I don't even want to. I don't even care. I just don't.
Your counsel simply relied on the personal history you provided in your trial testimony. There were no psychiatric or psychological reports provided, no references from character witnesses. No doubt that approach to your plea hearing was based on your instructions, but it means the account of your personal history that I am about to give is limited. You were born in Adelaide on the 30th of September 1974, making you 48 years old at the time of your offending and 50 now. Your maiden name was Scudder. In 1977, your family relocated to Melbourne, residing in Hampton.
Okay, that makes sense. Her maiden name was Gutter. Yep. Gutter.
2004, you and Simon Patterson met whilst you were both employed at Monash City Council. Simon told the jury that he was working there as a civil engineer and you were the RSPCA's representative on the council. By 2005, you and Simon were romantically involved. In 2006, your grandmother died, leaving you a substantial inheritance. Monies from her estate were distributed between 2007 and 2015. During those years, you would be generous with your money to Simon's siblings, providing large, no-interest loans to them and their spouses so that they could purchase their own homes. On the 2nd of June 2007, you and Simon married. You told the jury that your parents did not attend the wedding. They were holidaying in Russia. Soon after your marriage, you and Simon travelled around Australia and overseas for a few months before settling in Perth. Simon got a job working for an inner-city shire council. In 2009, when you were 34, your son was born. In April 2009...
Maria, does that describe your life too? Maria, This is how Maria grew up, guys. No, she didn't.
You and Simon set off with the baby to explore the top end of Australia. You reached Townsville in November 2009, at which point you parted company. You flew back to Perth. Simon drove back with the baby. You rented a cottage for you and the baby. Simon rented an on-site caravan close by. This was the first of many comparatively short-term separations. You reunited by the end of January 2010. In 2011, your father died. In that year, you also opened a second-hand bookshop in Pemberton, Western Australia. In 2013, when you were pregnant, you and Simon returned to Victoria with your son to live closer to Simon's family. In 2014, your daughter was born. In 2015, you and Simon separated permanently.
No! No, we're going out for a drink, remember? Remember? Don't skip the wedding.
2019, your mother died, leaving you an inheritance. In June 22, you and your children moved into a newly constructed home at 84 Gibson Street, Leongatha, the home at which you served the fatal lunch on the 29th of July 23. You have no relevant criminal history. You maintain your innocence. In other words, there is no evidence of remorse. I turn now to the conditions of your imprisonment. As mentioned, you have been in custody since the 2nd of November 23. There were 2 affidavits tendered relating to your conditions of imprisonment. The first was sworn by a solicitor who acts for you and was based largely on your instructions. The second affidavit was sworn by Jennifer Hosking, Assistant Commissioner, Sentence Management Division at Corrections Victoria, who also testified at your plea hearing. Ms Hosking's evidence included confirmation of the following matters. You have a, quote, maximum security rating and, quote, major offender status. Because of the nature of your crimes and your notoriety, you have been assessed as being at significant risk from other prisoners. You have not been assessed as posing a risk to other prisoners. You have spent approximately 16 months of your 22 months at Dame Phyllis Frost Centre in a management unit called the Gordon Unit, and the rest of the time in a protection unit called the Murray Unit. A management unit is more restrictive than a protection unit. You have been in the Gordon Unit continuously for the last 15 months. The Gordon Unit has about 20 cells. You are not permitted to mix with the other women in the Gordon Unit. You have spent at least 22 hours in your cell every day that you have been in the Gordon Unit. There have been 16 days since November 24 where, because of lockdowns, you have been confined to your cell for the entire 24 hours per day. The maximum period that a prisoner in the Gordon Unit could have out of their cell on any given day is 4 hours, but, quote, that wouldn't happen very often. Your meals and medicine are currently delivered through a flap in your cell door. There is a small concrete yard, approximately 2 metres by 1.5 metres, which adjoins your cell, which, with permission, you may access for fresh air. If prisoners are using the larger exercise yard, which abuts your exercise yard, you may not use your small yard. During your time in the Gordon Unit, you have barely had any contact with other individuals. Permission is required for you to communicate with any other prisoner, which, according to your counsel, is complicated by the fact that you are not informed of the identities of the other prisoners in the Gordon Unit. You currently have approval to communicate with one other prisoner in the Gordon Unit through a wire mesh when the 2 of you are permitted to use your respective adjoining exercise yards. That other prisoner is undergoing a lengthy sentence for terrorism offences and has attacked other prisoners. You did not ask to communicate with that person and have not communicated with her. The suggestion that you should communicate with her was made by a corrections officer. There is an intercom in your cell which, if permission is granted, you may use to communicate with one other prisoner in the unit at a time, but you have not done so. In order to attend any other part of the prison, for example, the visitors' centre or the library, you are driven there escorted by 2 corrections officers. While, theoretically, prisoners in the Gordon unit are able to access the prison library twice per week for 20 minutes at a time, you have not been able to do so because of staff shortages and a rule that you may not access the library if another is doing so. Consequently, you have only been able to access the library a handful of times during your time in the Gordon unit. United Nations guidelines, known as the Bangkok Rules, provide that a prisoner should not be in separation for more than 15 days at a time, but you have now been in separation continuously for 15 months.
That's crazy. They're not allowed to be in that area for more than 15 days. She's been there 15 months. She doesn't get to talk to anybody ever. Is that crazy?
There are 2 prisoners in the Gordon unit who have been there in excess of 3 years. And whilst the primary principle in the placement of prisoners is to manage and place them in the least restrictive environment necessary to ensure the safety and security of the individual prisoner and other prisoners, the least restrictive environment can be very restrictive. As for your future conditions of imprisonment, whilst your placement in the Gordon unit is reviewed monthly, Ms Hosking was unable to say whether you would ever be moved from the Gordon unit. I infer that given the unprecedented media coverage of your case and the books, documentaries and TV series about you, which are all in the pipeline, you are likely to remain a notorious prisoner for many years to come, and as such remain at significant risk from other prisoners. I turn then to a number of relevant sentencing principles and rules. Section 5 of the Sentencing Act 1991 declares that the only purposes for which sentences may be imposed are just punishment, specific and general deterrence, rehabilitation, denunciation, and protection of the community. I have had regard to all of these sentencing purposes in formulating my sentences, but rehabilitation has taken a backseat because of the gravity of your offending. Other provisions of the Sentencing Act that are of particular relevance to your case are as follows. Under Section 6A to 6F, you fall to be sentenced as a serious violent offender in respect of the 3 murders, meaning that the protection of the community is the principal purpose for which the sentences on those counts must be imposed. Under Section 6F, your status as a serious violent offender must be entered in the court records. Section 11(1) provides relevantly that if a court sentences an offender to be imprisonment for the term of her natural life, the court must, as part of the sentence, fix a period during which the offender is not eligible to be released on parole, unless it considers that the nature of the offence makes the fixing of such a period inappropriate. Section 11A(4)(a) provides that where an offender is sentenced to life imprisonment, the sentencer must fix a non-parole period of at least 30 years, unless it is not in the interests of justice to do so. Is it inappropriate to fix a non-parole period? Would fixing a non-parole period be contrary to the interests of justice? As mentioned above, this is the main dispute that I have to determine. Sentencing case law establishes that, as a general rule, harsher than normal conditions of imprisonment will warrant mitigation of penalty. There is nothing about your conduct whilst in custody which might cast doubt on the application of that general rule. As Ms Hosking indicated, you are in a management unit to protect you from other prisoners, not vice versa, nor do you have any relevant criminal history. In their written submissions, the prosecution conceded that your conditions of imprisonment are more burdensome than for a mainstream prisoner, and that they are likely to remain so for the foreseeable future. The prosecution submitted that this is a, quote, relevant consideration for sentence. In oral submissions, the prosecution conceded that this consideration was not just relevant, but, quote, important and, quote, weighty, while still pressing for life imprisonment with no possibility of parole. You have effectively been held in continuous solitary confinement for the last 15 months, and at the very least, there is a substantial chance that for your protection, you will continue to be held in solitary confinement for years to come. The Court of Appeal in Yatt against the King referred without criticism to the observation that, quote, the adverse health effects of solitary confinement are well established. I note too that Ms Hosking stated at the plea hearing that, quote, being separated has negative outcomes for people. We're very aware of that. The harsh prison conditions that you have experienced already and the likely prospect of solitary confinement for the foreseeable future are important and weighty considerations which should count for something in the sentencing exercise. In my view, the only scope for making them count is by the fixing of a non-parole period. In opposing the imposition of a non-parole period, the prosecution relied on the Queen against Colston, where the offender was sentenced to life imprisonment without a non-parole period for the savage murders of 3 people. But that case makes clear that, quote, where there is a substantial factor pointing towards clemency, as I consider your present and likely future conditions of imprisonment to be, the fixing of a non-parole period may be appropriate even for an offender who has committed multiple murders. Fixing a non-parole period is not to undervalue the horrendous nature of your offending. Your total effective sentence will be life imprisonment, and the period during which you will be ineligible for parole will be a very substantial one. Please stand.
Here we go.
For the attempted murder of Ian Wilkinson, I sentence you to 25 years imprisonment. For the murder of Heather Wilkinson, I sentence you to life imprisonment. For the murder of Gail Patterson, I sentence you to life imprisonment. For the murder of Don Patterson, I sentence you to life imprisonment. All sentences are to be served concurrently. The total effective sentence is life imprisonment, and I fix a non-parole period of 33 years. I declare that you have served 676 days by way of pre-sentence detention. Finally, and by consent, I make the disposal order sought by the prosecution.
So she'll be in her 70s when she gets out. Right, she's in her 40s now. She got 33 years. So she has the possibility of parole in 33 years. So we'll see. Listen, we'll all have to come back together in 33 years and see if she gets out or not. But yeah, I just don't understand. She's rich. Don't they have hitmen over there? I mean, let's look at a liar. Anybody want to watch a liar?
All right. Everybody be seated. Okay. We are back on the record, and Eric Russell, 22T9853. It's my understanding the parties are going to admit violations and then we're going to a sentencing argument. Go ahead, Mr. Alexander.
So, Your Honor, having spoken to Mr. Russell, I've just been blown away.
Wait, do we have,
Oh, she's on weapons.
I just want to make sure.
Sure. I've just been blown away by the amount of support that Mr. Russell has. I have 2 letters of recommendation from people that he's worked with Mr. Russell is very active and engaged.
Well, let me have him admit to the violation.
Oh, sure, sorry.
Cause you're like rushing to the sentencing argument, and I don't even have him in, I don't have an admission yet. So, what is he admitting to?
He's admitting to missing UAs.
Okay, so that would be condition number 7. Mr. Russell, you admitting that you failed to submit to drug and alcohol testing as directed by your probation officer?
At the place that the parole and probation officer directed me to go to, yes.
I'm not quantifying. So, Mr. Alexander, he needs to admit to, if he's not good on 7, find another condition. I got 7, I got 8, I got 9, I got 12. I'm not quantifying anything. It's either a full admission as to how it's written, or it is, we're going to hearing, but we're not quantifying the admission.
Right.
So find one he's willing to admit to fully.
Okay.
I did miss the US.
All right, so you're willing to admit, and condition number 7, that you failed to submit to drug and alcohol testing as directed by probation officer.
Yes.
All right, so court will take admission to the violation of condition number 7, and then Mr. Alexander, you have the floor in terms of your sentencing argument. Go ahead. You said he has support, and you had 2 letters.
Yes, I do have 2 letters, one from Randy L. Dunn, who has worked with Eric for a number of years. The other from Kaylee Lovegren, who more recently worked with him. Mr. Russell, he supports his 5 children with his ex-wife. He's currently working. He's very active. I believe he told me that he manages 5 businesses currently. He's very active in maintaining a sober lifestyle. He is involved in Narcotics Anonymous. He goes around to jails and hospitals and other places that are hard to reach and conducts Narcotics Anonymous meetings. He's also involved in Narcotics Anonymous meetings himself. He attends regularly, I believe, 2 times a day. Sorry? Sponsor. He has a sponsor, Eric Fisher. I was not able to get a hold of Mr. Fisher, but I know if I was able to, Mr. Fisher would be here in support of Mr. Russell as well. Mr. Russell has made tremendous strides. He's open about his struggles with addiction. He recognizes that he has problems with both drinking and cocaine. He is seeking to continue his clean lifestyle. He wants to hold himself to a standard that is even higher than probation, and that leads him to bump heads with probation as to the best way for him to do that. I believe that if Mr. Russell were to be revoked and regranted in this case, he would comply with probation. I've had conversations with Mr. Russell, and I made it clear that while he is in charge of his own destiny in terms of staying clean and staying sober, he does need to submit to probation, and he does need to submit to the court. Whatever he feels that his treatment may or may not need, at a bare minimum, it needs to include everything that probation is telling him to do, everything that the court orders him to do. And I believe that from this point forward, Mr. Russell will be a model person on probation. I believe that a change of scenery may do him good. He's currently voluntarily in sober apartment living in Wheat Ridge, Colorado, but he does have businesses down in Colorado Springs. He'd be willing to come back to El Paso County and seek out sober living here, again, voluntarily, and restart probation with El Paso County, where he was much more successful than he has been in Douglas County. Thank you.
Ow. Smurf, it looks like I have to resize it. It looks like I'll fix it so that way it'll pop up right away. It's just not sized right.
All right, and then I have a couple questions, follow-up questions for you based on your argument.
Mhm.
How long is Mr. Russell saying he has been sober?
My clean date was January 27th, 2023.
No, it wasn't. Liar. Liar.
Then why are we missing and failing to submit to UAs if you've been sober since 2023?
It was a misunderstanding that I had with Miss Lambert. I was in sober living where they were conducting.
I got a like from Brent today. Yes, sir. Yes, I did. It's not even over yet.
Regular UAs, both intake and on a weekly basis, as well as therapy. I gave them Miss Lambert's information. I never followed up with my sober living. They seemed to be a really high quality company. Turns out they were not. when I went for my most recent probation appointment with Miss Lambert on the, I believe, the 26th of January, she informed me that neither sober living place had been sending my UAs to her as directed. So I was under the impression I didn't need to go back to, and that was my mistake for not following up, and I own that.
All right. All right, I want to hear from probation next. Ms. Steinmetz, are you deferring to Mrs. Lambert?
Testerman, Your Honor.
Testerman, I'm sorry.
No, you're fine. I would defer to Officer Lambert because she directly supervised.
All right, Officer Lambert, you have the floor. Please inform me as to all the information you have on Mr. Russell so that I can know how to sentence him.
Yes, Judge. Also, good morning.
Morning.
Yes, as far as the UA testing goes, I'll start there first. He was on substance abuse testing. I referred him to RMS, Recovery Monitoring Solutions, for him to go test. There's various locations throughout the state. He has been testing since about July of 2025, and we've had missed tests. After the complaint was written, he did, well, actually, I think the positive should be on there as well. He did test positive. The last one that
No, he didn't, because his clean date is December of 2023. So he didn't test positive in 2025. You must be lying. You must be lying on him. It's a conspiracy.
took was positive on December 5th of 2025, and that was positive for alcohol. I think sobriety has been a big struggle for Mr. Russell. He's been missing a lot of tests. Right before he came for our last meeting, I had set him up on the breathalyzer so that way he can be blowing into a device, and that way there would be no excuse that he can't make it to a UA testing location or anything like that. He did not follow through. He did not follow up with the breathalyzer device. And then at our last appointment, that's when he was remanded because he had a warrant for failure to appear in court. So, I mean, it wasn't a full appointment for us to discuss the breathalyzer or anything, but there have been steps taken in place for the sobriety monitoring to help focus on
He's
being
innocent.
sober, basically.
Innocent.
And that's
And
as
Ms.
far as the
Lam-
UAs.
All right.
But
Okay,
if
what
you
else?
have any other,
No,
don't
I
know.
want you to go through. I want to
Okay.
know your full experience with Mr. Russell.
Okay.
Because I agree that essentially I've read the complaint report. There seems to be a theme of lack of accountability and a theme of kind of Mr. Russell doing what he wants to do and how he wants to do it and not complying with probation the way that it's been ordered. So I want to know what your experience has been with Mr. Russell because it gives this court the understanding in terms of what it needs to do in terms of the sentencing.
Okay. I'll start that. Obviously his case is from El Paso County and it was transferred to Douglas County. He had a different supervising probation officer before July when I took over his case. I think there was a point where maybe there was an appointment set or he wasn't meeting his appointments. I can look back and see, but I think it was in May is when he was told to report. So I don't know the exact date of when it was accepted here in Douglas County, but he was told to report in May of last year of 2025, and he did not report. And then in June, we don't have any notes, but in July when I took over the case, I did reach out to Mr. Russell. Didn't have an updated contact number for him, but he did respond to my emails, and then that's when we started meeting. I would say that I think he made most of his appointments. There was some maybe that he didn't miss. I have to go back and look the exact dates. But you know, throughout our meetings, we discussed him getting into community service. He did have to register over there in El Paso County to get it transferred to Douglas County. There was never any follow through on that. At one point, he did have a report to me that he wanted to go back to El Paso County and that he was going to move over there. There was no proof of residence that he was going to be moving back. So his probation stayed here in Douglas County. As far as treatment, he started his DUI treatment in El Paso County. He was going to a turning point. he was discharged twice from there for lack of attendance. And then in our last appointments in December, at least November, I know we discussed about him reengaging, going back into treatment. That he did not follow through, he did not comply with that. And the last few months, I think he struggled a lot with his sobriety. We had a meeting in December and he shared with me everything that he was going through, and that his father had to call the police, and that he was drinking, you know. It was very concerning. And after that, he told me he had a plan, that he was going to go into sober living. It is true, I did not get any verification of his UAs or anything like that from the sober living, but he was still on testing through probation, the place that I had sent him to, the locations. He was on the call-in line, so he was supposed to be calling in, and if he had a test, he can go in there. I did tell him that if he wanted the sober living to give me the results of his UAs, then I can decrease or I can work with it, but that wasn't happening. That's why we put him on the breathalyzer. And then I think it was just, I think mostly the sobriety monitoring. We had some tests in the office. We had to breathalyze him here in the office a couple of times. Overall attitude of being on probation and compliance. I mean, a lot of defiance, a lot of lack of accountability, like you said. I think that makes it hard to move forward and work on these sobrieties if you're not willing to admit or make those changes. If he were to be reinstated on probation, I don't know what he is willing to do different for the long term. To me, it sounds like if he were to be reinstated, it's just for the meantime to avoid any incarceration time. But I don't see that he's making any long-term changes, or that he has been throughout the time I've supervised him at all.
Okay, thank you.
I hope that answers.
It does.
questions. Yeah.
Thank you. Ms. Bloom?
Your Honor, the people are asking to close this case out with the maximum. We've heard from the probation officers and he's not complying with anything. It almost sounds as if he believes he's higher than the court system. He thinks that his way of sobriety is better than what we're asking him to do. And there's no reason to believe that that's going to change in the future. It sounds like Phil Lambert offered to work with him and what was available to him with his sober living, and he still did not follow through. We also kind of have a lie on the record that there was sobriety since January of 2023, when there was an admission in December to drinking in that month. So I don't believe that anything that is said today by the defendant can be taken with credibility. When he is still not admitting today to the faults that happened along the way during probation. So we would be asking to close this out with the max sentence.
All right. And Ms. Lambert, final question before I go to Mr. Russell and get his statement. Is the reason, and I don't see this a lot, that probation asks us for the maximum sentence. What I see generally is that probation says revoke and close with a jail sentence is determined by the court. I don't want to put words in your mouth, so I'm gonna allow for you to tell me, why was that recommendation? I think I can understand why it is, but I want you to tell me why that is the recommendation.
Yes, Judge. He throughout his whole term looking at not looking at being transferred from districts or anything like that. At the end of the day, there's no condition that has been completed. I think that sometimes a defendant puts fault on that time frame that he was being transferred, that he was not able to, but you know, when he was being supervised and regularly since July when I met with him, no conditions, no efforts to comply or to do any of those. And when I look at the termination date, which is May of 2026, that's in about 3 months. Still nothing in about the year that you've had the opportunity to comply and do all the court orders. I don't think that it's very appropriate that you go through this whole time. You know, why did you take probation in the first place if you were not going to do these things? And also here in Douglas County, the courts do ask us for jail time recommendation. So I think that also comes from working in this district that
No,
I
it's
put that
fine.
on there. Yeah.
No, I'm not criticizing
Yeah.
your
Mhm.
recommendation. I was just asking why you were looking or leaning towards the maximum, and you answered it adequately. So thank you so much.
Of
All
course.
right, Mr. Russell,
Yes, Your Honor.
go ahead. Anything you want to say to the court?
Yes,
Consider before your sentence?
I would like to say a few things. Should I stand or sit?
Sure.
Okay. I had not finished the clause when I was speaking about my original clean date was January 27th, 2023. So in September of this past year, you're gonna laugh if you own cats. I get up, I go to pee at 3 a.m. My black cat snuck in behind me and I tripped over it. I fell back and I hurt my spine, tore my rotator cuff and cracked my wrist. Over the succeeding 3 months, I could not sleep.
Torn rotator cuff? I gotta introduce you to someone, sir.
I was stopping going to meetings. I was sitting on my couch. I could not sleep, could not sleep. All the melatonin, all the yoga, all the everything in the world. I could not sleep. I started hallucinating. And at the end of the day, mid-December, the only thing I knew that was going to knock me out for one night was alcohol. I immediately got back into the program. I called my father, I called my sponsor, I called my business partner, my boss. They took me to the hospital. The next day I went to West Pines Mental Health. I was there for 6 days. When I got out, I immediately went into sober living after calling my sponsor. So yes, I did relapse in December. That was the only time I drank alcohol over the course of those 3 years. So to answer that question. So I was not finished with my statement. I was not intending to lie,
Okay.
but I wasn't done with the entire conversation there. I was just for brevity trying to get through that. My original clean date and the date that I started in Narcotics Anonymous with my sponsor was January 27th, 2023.
Drunken Smurf on Twitch, if you can't read it, said, take a lesson from that, YouTube viewers. Don't pee on your cat at 3 a.m. Karma is a real witch.
My sponsor is the state representative, the state chairman for Narcotics Anonymous hospitals and institutions. We go to rehabs, jails, rescue missions, and we take meetings to people who can't get out to go to them. That is my life. Okay. I sponsored 7
Talk
people.
about your life as it pertains to your compliance or lack of compliance
Sure.
with probation. I don't want to know about all your extracurricular activities, because what that shows this court is that you had the time to do the
Sure.
things you were required to do on probation and chose to do other things that were
Absolutely.
helpful to you.
Yes, and this last 16 days being incarcerated has been a very eye-opening and humbling experience. And I realize now that I've been speaking 2 dialects of the same language, that there is the Department of Justice's, here's what you need to do to comply with probation, and there is my Narcotics Anonymous, here's my long-term sobriety solution. And I did not follow suit. Now, as far as the failure to complete the DUI, I did complete level 2 education through 5280 HRCC. I completed that, I believe, the end of 2023 before I even pled guilty in here. I also completed 62 hours of the therapy. And when I completed level 2, I was not told I had to do the therapy. So there was a bit of a lag there. When I found out I had to do the therapy, I did enroll. And yes, I was discharged. However, I have completed 62 of the 96 required hours. I only have 17 classes left to do. So it was absolutely my intent to get that done before May. I just needed to call them, and wouldn't you know it, I went in for my regularly scheduled probation meeting and I was arrested. What were the other, what else? Community service. So it was my understanding when I originally pled guilty in here, and yes, I did drop the ball on this and I haven't reached out, but I've completed over 250 hours of inpatient meetings at rehabs that I was hoping would be counting
We
towards
have to say
community
that's
service.
lies, because
I
all he's
also
doing
feed
is
the
lying.
homeless at my church the third Tuesday of every month. I've done 4 of those. Those are
Court
3
ordered.
hours.
He
So
has to.
I've been volunteering and doing community service. I just haven't done it, you know, as you said, within the exact protocol required by the courts. And yep, I need to do a better job of that. In NA, we say progress, not perfection. I realized that I did not do the right work and I didn't do a good enough job, but I'm absolutely gonna do it now. You absolutely got my attention, so I do apologize to the courts. I in no way think that I am above the courts. If anything, excuse me, if anything, I was disorganized and, as you said, too
Jude!
focused on other
Jude, where the hell were you? Jude, welcome back. We missed you. We really, really, really missed you.
points of sobriety and trying to piece my life back together. Well, not exactly your words, but, you know, extracurricular activities. So I was trying to piece my life back together after 2022. I spent almost the entire year in rehab.
Ms. Lambert, are you done?
Yes.
Ms. Lambert,
Yes.
I'm looking at the complaint report.
Yes.
It says that the defendant tested positive for alcohol on October 10th of 2025, November 19th of 2025, November 25th of 2025, December 5th of 2025. And the October 10th and November 19th were confirmed as positive. Is that
Yes.
correct?
Yes.
So we have a lack of sobriety beyond December of 2025, correct?
You're saying sobriety or?
There's no sobriety, there's a lack of
Oh,
sobriety.
Yes, all the
outside of
missed tests,
December.
yeah, since December, missed tests
So,
and no
I
breathalyzer,
had-
yeah. Mhm.
Mr. Russell tell me he only lapsed in December, but you have positives for October and November as well,
Yes. Mhm.
that were confirmed.
And I
Okay.
don't know.
Mr. Russell, I've heard it. This is the thing. You talk a good game, Mr. Russell. But your game is just that. And you know better than anyone with all your narcotics classes and attendance and Narcotic Anonymous and whatever you go to, that the cure to addiction is honesty. You have to be honest with yourself about your addiction.
He is honest,
You have
Judge.
to be honest with yourself about your failures. And you're still not being honest with yourself. I'm not offended you're not honest with me. Doesn't bother me at all. I have people that walk through that door every day who are honest with me. But you're not even being honest with yourself. And in the statements that you made to this court saying your only lapse was in December of 2025, where there are positive tests in October and November, and God knows that's 3 tests.
Friend, that's not fair. I'm literally not allowed to react like that. If you or Bobby would go away for a while and come back because you're men, and that would look like special, like it would because you're men, because it would look like I have an interest. If I did that to a man that came into chat, it would look like I have a special interest towards that man. And if you've known me at all, so it's not fair. And especially if the man who comes into chat is attached in any way, wife, girlfriend, even a buddy, then I absolutely cannot show interest. No way. It's not happening for me. Not. Oh no, it's true. It wouldn't happen. Wouldn't happen. Couldn't happen. Couldn't. I have enough problems in my life. Trust me. On fire. I have enough problems in my life. I do not need an extra layer.
But you failed to appear for test in August, September, November, and December of 2025. When you were given the opportunity to give tests from your sober living place that was doing tests, You didn't do the follow through so that Ms. Lambert could have those tests and prove your sobriety. You didn't do the follow through when it came to your treatment. You didn't do the follow through when it came to your community service. You didn't do the follow through when it came to anything that you were required to do. What you did was what you wanted to do when you wanted to do. You didn't comply with probation. You're not in charge of your life. You've not been in charge of your life since you were placed on probation in May 6th of 2024. But you have been acting like you have been in control of your life. And you have been doing the things that you want to do the way you want to do it. And you're a complete violation of your probation. I'm in agreement with Ms. Lambert that what is the point of probation when you show little effort and little accountability? You're lacking that accountability now. And
Self-preservation
you're lying to this
is what
court
it
and
is.
to yourself. The court is not giving you another chance of probation because I'm not gonna waste the resources of this county or Douglas County when you can't even be accountable to your failures on probation. So the court does agree that the maximum penalty should be in this case, and the court is granting the request of probation for a maximum jail sentence. Tell me, Mr. Alexander, what credit he has for time served, please.
Your Honor, Mr. Russell has been in custody for 16 days, and he previously did 15 days of in-home detention.
All right, 31 days. All right. So, I don't even know if that's right. Is it 31 days? Yeah. All right, so 31 days. So you'll get 31 days of credit with his sentence for 364 days. Probation is closed. Good luck to you, Mr. Russell. Hope you can start being honest with yourself, because that's the only way you're gonna be clean.
Hedwig. Smurf says the work's been reversed too. Let a guy show up to soccer practice and talk to any of the females there and watch the gossip fly. It does. It's true. It's true. It's bad. All right. We're going to keep going. I do not want to stop right now at all. We did mushroom. I don't know. I'm going to do that some other time. So I'll do it some other time. Not doing it now. But you know how we've been watching these RICO cases in Georgia? Where they're bringing drugs into the prison and everything. We got a sentencing for one of them, but it's really boring. I know, address meltdown. Here we go. Let's do that one.
Like we have all the parties, so I'll ask staff to please put us on the record. All right. Good morning. My name is Magistrate Hannah, and we are here today in cause 49D03 2510 CC 049508. Plaintiff First Financial Bank NA versus defendant Scott Earl. To begin, I'd like the parties to...
Okay. Her voice is annoying you, but just wait till the man comes on. Just wait. Just hold your opinion until the man comes on, Smurf. Hold on.
Please state and spell their names, beginning with counsel for plaintiff.
Yes, Judge. My name is Bryn Thompson. I represent First Financial Bank, and my name is spelled BRYNNTHOMPSON.
Thank you. And Mr. Earl, could you please state and spell your name?
It's Scott Earl, SCOTTEARL.
Now just
All right, thank you.
imagine that voice, Smurf, when he's highly irritated and yelling at the judge.
Now, we are here today. Mr. Earl requested a hearing on plaintiff's motion for summary judgment. The court, I'm looking at the case now, and it shows that Mr. Earl filed an answer in November, and plaintiff filed a motion for summary judgment in December. The court issued a scheduling order, and Mr. Earl did not respond to the motion for summary judgment, but did request a hearing. So the court set this matter for hearing. Now, since plaintiff filed the motion for summary judgment, they go first. So Ms. Thompson, would you like to begin?
Yes, Judge, it'll be brief for me. We would stand on our motion for summary judgment. We filed that on December 5th. As the court had already mentioned, the defendant failed to respond, and we filed our motion to enter on January 12th, which was way after defendant's deadline to respond. So we would stand on our motion and ask that the court enter or summary judgment entry.
Thank you. Now, I'm going to briefly review for Mr. Earl because I don't know if you've had an opportunity to look at all these filings on mycase.in.gov, but I see that with their motion for summary judgment, plaintiff filed an affidavit of debt, and they filed a request for attorney fees and a non-military affidavit. So, Mr. Earl, I'm going to ask you now if you have any response to that you'd like to make in the way of argument.
Yes, I did do the initial response. That is incorrect. I did send it. I got a card stating it was scheduled. I got that card after the hearing had already been held. It did not come in my mail till then. And that's why I asked for another hearing because I didn't even know about the hearing, but yes, I did respond. That's 100% incorrect.
Well, I believe
also,
now wait a minute, Mr. Earl, are you talking about the response you filed in November?
Yeah. After that, I never got nothing. So
Take a day off. You can. You can just call in sick today. Just, I can't come. Oh, no. Better. Send a text message. I can't work today. I do not feel good. Just try it. It'll be fine.
Oh.
Yeah, yes. Well, the court finds that you did file an answer. Yes, I do see that.
Okay.
And wait a minute, let me take a look here. And it shows that you did file your answer, but are you saying that you did not receive a copy of plaintiff's motion for summary judgment?
No, I did not.
They filed that.
Everything keeps going to my ex-wife's house. Nothing comes here, even though you have my address. And I get half the stuff here, half the stuff at her house, and I have no contact with her at all. So, she keeps getting things I don't.
The address that the court has for you is...
Yeah, that's totally incorrect. On everything I filed, I have my new address. I get cards here with the new address, so you guys must have it. Because I'm getting 3 or 5 cards that tell me what's going on the case in the mail, but I got the papers going to her house. So it's kind of, and then also, for the last hearing...
I never call in sick, ever. My eyes could be bleeding and I will go to work. Ever. Ever will you see me call in sick. Ever. Come at me, never. But you can call in sick today. Just call in and say, I can't make it, I don't feel good. Diarrhea. Use diarrhea, that works.
It says that I was
Wait a minute,
Mr.
Earl, let's just clear up this address thing first.
Yep.
If you get the green cards, they would be going to one of...
They're white cards, and I've never got a green card.
But they should be going to one. Is that where you're living?
No, that's my ex-wife. I haven't lived there in over 2 years. I'm getting cards here with the correct address. But then I'll get one with a thing over. Like I got one right here, looking at it from Victorian Supreme Court. The address, apartment 21.
Yeah, but I didn't call in sick. I took 2 days off of work. I did not call in sick. You know, Bren, most people do that every week. Most people take 2 days off every week. I go months without taking 2 days off. Months.
Okay, let's let Ms. Thompson say something. Go ahead, ma'am.
If I may, Judge, I don't see any filing by the defendant in this case where there has been an address included. If I'm missing that, I welcome it to be brought to my attention, but I don't see any filing that the defendant has filed with the court that has an address at all, period. I would also say that once the defendant participates in the lawsuit, it's up to the defendant to make sure that the court has updated contact information as well as being updated with the filings in the case.
Thank you,
And then
Ms.
you're
Thompson.
wrong, because how did the court
Now, wait a minute, Mr.
how would the
Earl.
court have my address?
Mr.
No, I don't
Earl.
like being told stuff that are false facts. She's not
Mr.
telling the
Earl,
truth.
Mr. Earl, I'm trying to ask you a question. This is Magistrate Hannah. Because when I go back to the answer that you filed in November, it is, it's 3 lines long and it does not have an address on it.
Well, how did you guys get my address then? How am I getting cards from Marion County Courthouse? Tell me.
Unless the post office is forwarding them to you, and I'm
No,
going.
it's not a forward
let me
address,
look-
ma'am. It is a pre-printed card from the courthouse. Pre-printed.
Well,
There's no
Mr.
green
Earl,
sticker on it.
Mr. Earl, what is your address?
It's 17 Russell, Indiana, 47129. I'm getting things in the mail for you. That is the incorrect truth. You know,
Somebody help me. I can't get there. There's this one country and western song, Earl Must Die. Is that what it's called? It's extremely popular. Like, everybody knows it except for me. I just know enough to know I forget. I think it's Earl Must Die, right? Monica, thank you for the cheers.
the truth. Neither one of you.
Well,
Because you have
sir,
the address. Period.
I don't know how you're getting cards, but I'm looking at your case right now, and the only address listed is the one I.
Well, then I suggest you go to whoever sends out your card
Hey,
and
Mr.
find out
Earl.
where they got the address.
Mr. Earl, can you repeat
Yes.
your address, please? I wasn't able to write it all down.
Well, call your courthouse and they'll have it.
Mr. Earl, the court's going to
Who
find
sends
you
out
in
these white-
contempt if you don't
Who sends
behave.
out? No, who sends out the white card?
Mr. Earl, this is Magistrate Hannah, and I'm asking you for your address.
And I've asked you questions also.
Mr. Earl, I'm going to conclude this hearing unless you can give me an address.
Well, you can find it, but it's Sienna 47129.
Did you say Foxville?
Parksville.
Foxville?
What are you talking about? CLARKSVILLE. Parksville,
Thank you, Smurf.
Thank you.
Indiana.
And the zip code?
You're welcome. 47129.
Okay.
Now, how did all the records say that I was
Thank you,
present
Kelly.
at the hearing the last time?
Well, it does, you're right, it does say you were present.
He was present. Thank you, Lisi. And he's going to tell us about that right now. It's not pleasant. It's not pleasant what he's about to say. Thank you, Hedwig.
Well, that's incorrect.
And-
That's the typical courthouse. It's incorrect.
Well,
I was
Judge-
not there.
All right,
I don't even live
Ms.
near there.
Thompson, all right, now you've had some time to talk. We're going to let Ms. Thompson say something.
Judge, the previous hearing, I believe it was the December 17th hearing. It was a CMC and it was a telephonic. It was by WebEx, and I believe the defendant appeared the same way being called in. I can't remember if we appeared telephonically or by WebEx, but I remember the defendant being called into the hearing because he had not appeared on his own. So I believe court staff had called him.
Now, I saw that the other defendant's been dismissed.
That is correct, Judge.
All right.
Why is that?
Well, the court's going to send out a pro se litigant notice now that we have your address. And
You've had it. You've already had it.
well, I'm not going to dispute that with you, but I'm telling you that it's not in the court's record. All right.
Well, then
Now,
somehow the courthouse got it. So
And
can I address that
So-
phone call?
we're
You
here
mentioned-
today for a hearing on
Judge?
summary judgment.
Your Honor,
Yes.
can I
Mr. Earl?
address her comments about the phone call hearing?
Well,
Well, I
I'm
should she make an
looking-
accusation So why can't I address it also?
Just a minute, I'm going to read to you what's in the court file. It says, hearing journal entry, hearing date 12/17/25. Present Attorney Craven, Thompson, and defendant Scott Earl. WebEx case management hearing, plaintiff by counsel, defendant in person, court and parties discuss case. Court will rule on pending summary judgment motion when ripe. Now, Mr. Earl, did you have something to say?
Yes, on that phone call, it's jogging my memory because I wondered who the heck called me. And I've got two things going on, one with the ex-employer and then you guys. So I got a phone call and I can almost hear the voice, and it sounds like yours, Your Honor. The voice that I heard, and it was asking me, it kept saying, you told us to call. You requested this thing. He said to call. I had the flu. I was throwing up while I was talking to you on the telephone. You guys disconnected. There was no participation whatsoever. None. I could not even understand what you were saying. I was throwing up so bad. And then you guys are saying I was present and I participated. That is the whole untruth. It's the total untruth. I did not participate in anything.
Thank you, Mr. Earl.
What?
Now
I wasn't done.
Well, there was no action taken at that hearing. So now we're talking about today's hearing, which is a summary judgment hearing.
I don't like lies in court records. I don't like lies in court records.
Mr. Earl, do you have anything to say in response to plaintiff's motion for summary judgment that you owe this debt?
Yes, I will be filing bankruptcy today. So good luck.
All right. Thank you. That concludes today's hearing.
Thank you.
Goodbye. And do I have a proposed order?
Yes, Judge, the court should have one in the court's queue.
Okie doke. Thank you, Ms. Thompson.
Hope you have a good rest of your day, Judge.
Thank you.
Look, I'm going to keep going. I don't want to stop yet. I don't feel like stopping. How big is this one? Hopefully it's not too big. Oh, it doesn't say. Okay.
Your Honor, we have Mr. Hefner on Station 3.
All right, thank you. Mr. Hefner, did you understand your rights on advisement today?
Yes, I did.
All right, thank you. And are you a current member or a veteran of our military?
No, I'm not. Oh.
Sir, I did find probable cause for your arrest. You okay?
Yeah, so I'm just really bad. Oh my God, really bad indigestion.
Okay.
Oh, it hurts really bad. Sorry.
Yes, sorry about that. That's no fun. So I did find probable cause for your arrest. We are here to address bond in your matter.
Okay.
Charges have been filed. You were charged with DUI, DWAI, alcohol or drugs. That is an unclassified traffic misdemeanor. An uninsured motorist violation, which is a class 1 traffic misdemeanor, careless driving, which is a class 1 traffic misdemeanor, seatbelt violation, which is a class B traffic infraction, and expired plates violation, which is also a class B traffic infraction. And I'll hear first from the people. Ms. Belker.
People are in agreement with the recommended cash bond and standard supervision with each of the recommended conditions. There's a pretty extensive criminal history, not only in Colorado, but out of, it looks like 4 different states. Active warrants out of 3 different states at the time of this, though not all of them were extraditable. And there's a failure to appear.
Bren, when you call in sick for today, do that. Do you want me to rewind it so that you can memorize how he did it? You can do that.
History of 15, overall CPAT score of a 4. So we do think a cash bond is appropriate.
All right, thank you. And Mr. Mulch?
Judge, Mr. Hefner does have a bit of a criminal history, but he does live in the area. He's working as well. I'm not sure about what happened with the express consents, but obviously we'll have to deal with that once discovery is provided. I would say limited funds here, so I'd be asking for a straight PR bond, or if not, a low cash bond.
All right, thank you. So I certainly have concerns for community safety, just given the allegations in the affidavit. Which included a vehicle crashing into a property. There was an indication in the affidavit of Mr. Hefner attempting to leave the scene, which gives the court some concerns as well, for his willingness, ability to just follow orders, essentially. That in conjunction with Mr. Hefner's failure to appear record, which I note there are 15 failures to appear, and most recently there were 2 in 2025, along with a high-risk category and score, do indicate to the court that it is reasonable and necessary to issue a monetary bond. I am going to set bond per the recommendations of our bond commissioner at $175 cash bond. And sir, as conditions of bond, I am going to order that you remain law abiding, that you not drive without a valid driver's license, and I am going to require that you be supervised through pretrial services for their standard supervision.
Sir, there's no way I can post that bond, Your Honor. I just started working. I understand that there's the past not failure to appear, but I was homeless. I was on the streets and I was all messed up.
He has nice pipes. Like, so, he would be enjoyable to listen to in movies or reading a book or something.
I'm working now. I need to be able to get to work.
Not his work,
This would set me back extraordinarily for where I would be, just right back where I was, Your Honor. If you like that type of person, then you're just aiding in that type of person being presented back to you again, with me losing my job, losing my place to live. I mean, that's created a hardship for me. As far as leaving the scene, Your Honor, I had no cell phone service, and I was walking to an area with another gentleman who lived in the area to get it.
You really don't want to talk about the facts of the case. Those things can be.
I understand that, but you talked about the fact of the case, and the fact of the case is that I did not try to leave the scene, and that's all I'm going to leave that at. Now, as far as my job goes and everything else, I will lose my job. I'll lose my opportunity at where I live. I need to be out, Your Honor. Now, if you want to give me the opportunity to appear, I would need to be granted the opportunity to appear. You know what I mean? Without that, then I don't get that opportunity. Please give me that opportunity, sir. Please.
And I'm not going to do that. I just have
You
too
suck.
many concerns for your willingness to show up. If 15 prior failures to appear.
Well, give me an opportunity to appear, sir.
2025.
Give me the opportunity to appear.
opportunity.
Give me the opportunity, and I'll show you, and I'll prove you in your court wrong.
So,
Please.
sir, I'm not going to do that. I've taken everything
Why?
into account, and I am going to set bond in the amount of $175.
Did you take into account that I might show up?
So
You didn't take that into account, did you?
all right.
Did you take into account my job? Did you take into account the place where I live? You didn't take.
He took into account 15 failures to appear.
So I've muted you, sir. I need to make my record. I'm not going to change my mind. So conditions of bond are that Mr. Hefner remain law abiding, that a report to pretrial services within 24 hours for their standard supervision. That will include their monitoring of his sobriety as directed by pretrial services. The court's going to order that he not possess or consume any alcohol, drugs, or recreational marijuana while being supervised. The court will authorize MIPS as well as random UAs. Mr. Hefner's next court date is going to be March 10th, 2026 at 1:30 p.m. in courtroom L1. Hey, Mr. Kaywood.
Before we go to the next case, I have to stop for a second. A couple times you guys have said we have really nice numbers today. Okay, let me put it in perspective for you. So yesterday, when I showed Sue, YouTube had shown my title and thumb to 30,000 people, probably across the pond. I'm not sure. I didn't look. I can look, but I didn't. 30,000, okay? Today, YouTube has shown my title and thumb to 282 people. That's it. Terrible numbers today. But we have a lot of Vibers that came out today. The people who are watching today are Vibers. It's not new people that YouTube is showing my channel to. That's not happening today. I don't know why, but it's fine. But today, our numbers are strong because of people who are Vibers, and I thank you. I do thank you for coming out today. You guys are doing a really good job today, and I appreciate it.
This is Magistrate Doak. I'm going to ask you a few questions with respect to the two different complaints that you filed. And I've just read through the one, and I believe these are both just based on my reading of that it's the same complaint, just different names for the...
Oof. Vibers. Vibers. That's what we call people who watch court vibes. Vibers.
restrained party, is that correct?
Yes, your husband and wife.
Okay. Yeah, so it's the same. Okay. All right. And so I'm going to ask you a few questions. Can I have you raise your right hand when you get a chance?
Yes, sir. I'm ready.
All right. Now, do you swear or affirm under the penalty of perjury that any testimony you provide me will be the truth, the whole truth, and nothing but the truth?
I do.
All right. So how do you know Daniel Anderson and his wife?
I was in the Fremont Department of Corrections with Daniel Anderson. That's where I met him. We were both serving sentences. And we had got out, and he got out in 2020. I was released in 2021. He had started a business. The business started doing well due to COVID. He brought me on to help with the business. At some point, he decided he didn't want to do the business.
I hope that everybody who watches this clip takes from it, do not get into a business relationship with the people you serve time with in prison. I don't know how else to say it more clearly.
More so, he sold it to me for about $680,000. I purchased the business, and I had to. It kind of got a little complicated, a little messy in there. Leslie Anderson, who was his girlfriend at the time, they knew each other because she was in Ohio Department of Corrections for attempted murder of her husband, and he did some legal work for her. He talked about her while we were in DOC together. We both went through treatment together in Fremont, offense-specific treatment. Anyway, so I bought the company. He had a hard time. She didn't really want him to sell it to me. We already had the contract. I had made my payments. I completed the payments. And at that point in time, they were getting closer, and it was kind of spiraling. Our relationship was beginning to sour because of their involvement trying to get the company back after I was making payments and et cetera. So that's kind of how I know him.
Okay. And you're indicating that they've been harassing you, kind of cyber harassing, is that right?
So I went back to, got revocated on my parole I live in Florida with my wife and my businesses. I have a couple different businesses out there now. So I had a technical violation. Right now I'm currently working on getting my life back together, substance abuse issues. I came back. I'm currently incarcerated at the Larimer County Community Corrections, 2255 Midpoint. Tiffany Thompson is my case manager, and she's well aware of everything I'm doing. So when I went back on my technical violation in December 20th of 2023, I got revocated. I went and saw the parole board. They put me back in. I went to Bent County. At that point in time, there was I had an employee of mine I had fired. I voiced to text. I accidentally said the word. I said the word sue. The Gemini program interpreted for the word shoot. He was upset that I fired him. They ended up charging me with a petty offense, credible threats, and disturbing the peace in Denver City County. I went to trial, was found guilty of that. It didn't have anything to do with my parole violation because it was for substance abuse technical violation only. At this point in time, Leslie and Dan Anderson were really wanting to try to get the company back. They had kind of they jumped on that case. Things kind of spiraled out of control. They had then, while I was in the Denver County Jail, he tried to submit multiple times to try to get this business back through legal means, saying that I violated the contract, blah, blah, blah. I had litigation attorneys handle all this stuff for me. Needless to say, I went to Bent County. His wife got a went to file a civil restraining order saying that I was threatening to violently rape her and cut her head off and all this crazy stuff. I had hired an attorney to represent me. We did not be eye to eye. He did not get me at the hearing, Pueblo. And because I was not at that hearing, the judge granted the restraining order for her. Daniel Anderson tried to get a restraining order, but they did not grant it because they didn't find him credible. This is in the notes of the restraining orders down there. And so once they got that restraining order, I just learned this recently from Melissa Smith, the Deputy Director of Prisons and Department of Corrections. She emailed me and my wife a letter explaining that Leslie Anderson falsified information along with Dan to get on the VINE system, the VINE alert system, the victim notification system, saying that she was my statutory victim. She claimed that the civil protection order was saying that I was a victim of hers, but there was no crime committed to get this. And so while they were giving her a quote unquote courtesy assignment on the victim notification system, they come to find out, and I have this email from Melissa Smith, just so you're aware. She put this in the email. This is what really prompted me to go through with the civil protection order. They found out that they were attempting to harass me the whole time I was in Bent County, and I have such a plethora of emails and information to back this up. Dan was sending me emails taunting me in Bent County. Keep in mind, he also tried to get a restraining order saying I was trying to hurt him and his wife, right? And so I have all these emails from them, e-messages saying that taunting me, saying, the party gets started now. Now your business partner, he's going to get it. And they reached out to.
I also hope you take away from this that you guys can all start your own businesses. These two prisoners started multiple businesses and got loans for $600,000 for their businesses. There's no reason why you guys can't start your own business for something.
My best friend, my trust administrator, Carol Bemister, they contacted her at her church and pulled her out. Also, her husband, they contacted my therapist, my mom.
I absolutely was not trying to be rude. I just missed the sausage part. I meant go get a sausage sizzle, I was trying to be Australian, and I just won't do that anymore. I learned my lesson right now.
My attorneys,
hang on.
Everybody. Yes.
Sir, hang on 1 second. There's kind of a lot of background here, obviously. So hang on 1 second. I just need to make a determination as to what, if there are grounds for the issuance of the temporary restraining order. So let me go back. So you indicate that there are a number of emails that have been sent to you, harassing emails. When were these emails sent? Just kind of general ballpark. These were this year, last year? When were these sent?
They've been continuous for 2 years, sir.
Okay. And how many emails?
Look, I'm right beside Philadelphia. I'm just going to stick with Philly. That's what I'm going to stick with. That's what I know. Do you guys want some water? I'll get you some water. It'll make you feel better.
Have you received?
I don't know, probably about a dozen. My wife has gotten emails. All my friends, they email all my friends and families and everybody. So to go back to the letter to try to surmise this for you a little bit, Melissa Smith wrote me an email saying, Daniel Anderson and Leslie Anderson have been attempting to harass you. They falsified information to get on the victim notification alert system. She's like, if I were you, I would go get a restraining order. And we, they basically lied to get on this victim notification. I went down to the Pueblo Police Department, tried to get them to file a case. They would not. My mom and Carol Bemister have I have police reports filed against them from my mom and Carol Bemister, my trust administrator, my mother. So we have filed police reports. We haven't gotten anywhere with them. But again, this has been ongoing all the way up when I saw the parole board. So going recent till 2025 September. I saw the parole board in September. Dan and Leslie both, at this point in time, I had a direct order from his parole officer for him not to contact me. He went to his parole officer with his wife, was able to sit in at my parole hearing and speak at my parole hearing. I found out after the fact by my case manager, because I was in Trinidad Correctional Facility. that very same week, he was also sending me emails trying to be friendly with me, right? Manipulating the situation while he was, and I have all this to prove. Like literally, if you give me a chance at a hearing, I have so much information that it will blow your mind. And I promise you, I promise you, it's overwhelmingly, I will convince you that these people are stalking, harassing me, and cyberbullying me.
So,
Please, just give me a,
so hang on a second. So I need to get there. So I've heard that there's a bunch of emails. You indicated that there were so many emails, but there were 12 over the course of 2 years is what I heard.
To me specifically, but there's more than that to other people that are directly in my orbits.
Okay.
About me. They're only emailing them. They're only emailing them to get at me. Like these people don't even know Dan and Leslie.
All right. So what is it that's being said in these emails? You indicated that he was sending emails trying to be friendly with you.
Have you heard of doxing? They're doxing me.
Yes, I have. You indicated.
Okay, so
hang on. You indicated that he sent you some emails trying to be friendly with you. You stated that there had been an attempt to try to get the company back. What if anything, have they stated to you that would be threatening or anything like that?
Stalking, harassment, digital harassment, and cyberbullying. They're naming my company. They put out Facebook posts. They've created a YouTube channel. I have all this. They created a YouTube channel specifically about me.
People who create YouTube channels are evil.
And they got my phone calls through a Coral request, illegally obtained phone calls, I might add, from the Department of Corrections in the Denver County Jail. Right? They're not law enforcement personnel, but they have copies of these phone calls. I have emails saying that he got these phone calls, saying that he's going to make me famous. I also have an email saying that he posted something on, and I quoted this in the document that you have there, that he basically posted. I'll read it. I'll pull it up here. Let me pull it up. It says, "Showing a little love, that's all. From Daniel Anderson to Leslie Long and Corbett Hutchinson. Anyone in the Longmont and Fort Collins area recognize this guy." And you keep going on. It says, he's coming back to town in a little bit. He'll be at Comcor 200 West Oak very soon. Be sure to show him a warm, capitalized warm welcome. Basically, right? So I'm fearful of this. Honestly, it has my business in this email. There's my business partner. The name of my business is. My wife is in there. And there's also generated AI technology. It shows a picture of me in this email. It says that I've frauded people millions of tens of thousands of dollars. Small business owners have to pay credit lines reports. Andrew Kaywood is coming.
Millions of tens of thousands of dollars. That's how bad he defrauded people.
Back in prison for a third time. He continues to run schemes of fraudulent empire and from behind bars with the help of Jay Paul and Rebecca. Want to listen to some of Andrew's prisons calls? It's great fun. It's totally free. Just visit YouTube. Phone calls from the penitentiary.
Okay,
that's one email. You go to the.
Let me ask you. You indicated both here today and then in your complaint that your let's see.
I have a witness that will go. On the stand that basically that Daniel Anderson said if he runs out of resources that he would if he saw me in a parking lot he'd shoot me as well. Now I never heard that.
Who did you hear that from?
Gail Corbett Hutchinson, who's on the email chains,
and he told you this.
Yes.
And how does
he said that Dan told him that because Dan and Corbett Hutchinson and Leslie used to be business partners together as well.
And this is something that
if he was subpoenaed, if he was subpoenaed, absolutely he would.
Now, what I'm asking you, this is something that he told this witness of yours.
Yes, he said that he told it to him on the phone.
Okay. All right. So I am going to grant the protection order on both accounts here. We will get these matters set ultimately for permanent protection order hearings. Now, with respect, so you indicated you have a ton of emails, and you also have, you stated in your complaint that, give me 1 second here.
Hearsay is allowed in probable cause, but just that's why the judge is allowing it right now.
So that Melissa Smith, a lot of information comes from Melissa Smith.
It makes sense that hearsay is allowed in probable cause because it's not the trial. And probable cause is just, this is what I'm going to prove at trial. This is what happened. So it makes sense that hearsay is allowed. And then we expect that this guy is going to call those people as witnesses at the trial.
Is she going to testify on your behalf?
I don't know how to submit information to the court, right? I have an email that addresses all this on the DOC letterhead, and I'm sure that if she was questioned about it, she would confirm everything in the email. And so if you feel that it's necessary, then I will work on
The judge doesn't tell you what to do with your case, sir. You have to figure it out.
getting her to testify. I'd probably have to be via phone, but yeah.
Well, I have to comply with the rules of evidence. Hearsay is one of our foundations for rules of evidence. Emails from somebody else is hearsay. Statements from somebody else, not a party to the case, that is all hearsay. So we will get these matters set, but it sounds like much of what you're relying on there is what you've heard from other people. You've gotten a number of emails. Based on what you're telling me about those emails, I'm not certain that would rise to the level of harassment. I understand you feel a certain way about it, but in terms of the content of the emails, I'm not sure without.
Now, he's still going to set the hearing for the protection order. He used that information to set the hearing. But he's trying to tell this guy that you have to bring these people in. You can't just say what other people say. You have to bring these people in. But even if you do, it's probably not going to go well for you.
You being able to develop that more fully at a hearing, just based on what I'm hearing, it doesn't sound like that would rise to the level of stalking or anything like that. But that's up for you to try to develop at the hearing. We will get these matters set. When can we?
March 3rd at 10:30.
Yeah, we'll set it. How much time do we have for that?
We could do it.
Yeah, I'll just set it for 90 minutes.
We could move them to Monday, 2nd at 9.
So we'll get these, and do we have anything behind that? Okay, so we're gonna get this set March 2nd at 9:30. And what we're gonna do is send you what's called a service packet. And that's going to include your complaints, my temporary protection orders, and I am naming you as the restrained party, not naming anybody else. You indicate that you want 5,000 yards distance. I'm going to order that they remain at least 50 yards from where you are, which is pretty standard.
Yeah, I didn't know.
I'm going to order that they not have any communication with you.
It works. Just say it with your chest.
Now, with respect to what, if anything, they're posting, it's really outside of the jurisdiction of the court. There's there's this thing called First Amendment. They can post things, but certainly if they're
Just checking. High level business meeting in Australia doesn't mean like bathroom or something, does it?
making any threats or harassing you or anything like that.
What about harassment of my businesses that are, right? Like my businesses,
Sorry.
I have
It doesn't mean Dunny, does it?
complete anonymity with my businesses. And the only way that they know that I owe these businesses is because they got illegally obtained information through a CORA request, through the Open Records Act, through the Department of Corrections. And so they're attacking those businesses online. And I don't know if you know anything about how SEO and stuff works online, right? That's very damaging to my business and to my financial well-being,
SEO is,
potentially.
nobody.
I'll take to great strides to make sure that I'm completely anonymous in these businesses due to my criminal background.
So the jurisdiction I have is to issue protection orders that can protect people against harm, physical harm, any threats of violence or anything like that, bodily harm. Now, certainly harassment, coercion, things like that.
That's the place of business.
Well, and so that may be outside of the scope of what the court really has jurisdiction for. And there may be other things that you'll have to pursue in terms of what, if anything, that they're doing with respect to that. Well, I'll hear the matter and make some determinations as to what, if anything, I would be doing in terms of protection orders. So we'll get the matter set March 2nd at 9:30. We'll send out the service packet. There's going to be 2 of them, one for each person. They will include your complaints, my temporary protection orders, the notices of the hearing. You will have to get these served personally, complying with the Colorado Rules of Civil Procedure, specifically Rule 4E as in Edward.
Wait.
And that
I'm confused. Okay, maybe I just was wrong this entire time. So he is filing for a protection order. So there's a civil protection order and a criminal protection order? I just assumed a protection order was always criminal. But I'm wrong. There can be civil I guess trespassing would be a sort of civil protection order. But no, that's criminal. I don't know. You and me both, Bobby, very soon.
Yeah, and that just states that you have to use somebody over the age of 18, not a party to the case, has to personally serve them. And are you currently in custody?
I'm technically considered incarcerated, but I'm at the community correction, so I can leave and go do things in the community, just like I was able to come down there today.
Right. So you can go through the sheriff's office. They have
is that a viable option for me?
It is. They have a civil service unit there that does this. They serve people with civil packets. So you can certainly use them. You could hire a process server. If you are able to get them served, you'll file a certificate of service in each matter. And if they are both personally served and don't appear, the court then would issue a permanent protection order. If they are both personally served and you do not appear, you're not required to appear, but I likely would not be able to make the findings that I need to issue a permanent protection order without further evidence or testimony. Now, if you are not able to get them personally served, you'll want to appear on that March 2nd date. And if there's a request by you, I would issue essentially another service packet, set a new court date, and allow you the opportunity to get them personally served.
Okay, Judge, what was your last name again?
Doak, D-O-A-K.
D-O-A-K. Thank you. I'm sorry I didn't get that written down when you said it the first time. Thank you. Thank you, Your Honor.
All right, so we'll get these set. There are going to be some instructions there with respect to exhibits and things like that. If you are going to introduce exhibits, i.e. emails, et cetera, we'll need printout copies of all those. You'll want to prepare 3 copies per case, essentially. And then those just go through an evidence process. That I need to make determinations on their admissibility. And again, I have to comply with the rules of evidence. Okay.
Yep, I understand. I definitely want this done the right way, which is why I'm coming to you and asking for help.
Okay. All right. So we will see you back here on March 2nd at 9:30.
Will I come in person or will I come on the phone for that one?
You'll appear in person unless there's a request
He's in
to
Florida,
appear
Judge. He's in Florida.
virtually. Now, appearing virtually is, I allow it.
I don't mind. I don't mind being there in
if
person.
there's good.
I'd prefer to be there in person.
Well, and it makes it very difficult to get exhibits introduced if you're appearing virtually. So there has to be a good reason to allow it.
Nope, I'll be there in person.
Okay. All right. Very good, sir. So we'll see you on the 2nd.
Thank you so much, sir. I appreciate your time, Judge Doak.
All right. Bye now.
That's going to be a train wreck. That's going to be a train wreck. I wonder what the other convict is going to say, if they even show up. I don't know. So just because the camera only goes from here up, every time I'm always full. Sometimes, okay, not gonna lie. Sometimes my pants do not match my shirt, but it's always there because the biggest worry is that I accidentally have to get up and get something and I forget to turn my camera off. So even if I forget to turn my camera off, I am always 100% okay. There was one stream, one time, way back at the beginning, where I didn't. And I mean, I had a very long shirt on, but not that long. And ever since that day, nope. So Bobby, I would love, I didn't moon this stream. I back of my leg to the stream. And ever since that day, never, I come extra fully dressed. I mean, I don't have socks on right now, but normally socks too, just in case. So when I listen, because it's hot and these lights are freaking bright as hell, especially at 4:30 in the morning. They're bright and they make me even hotter, and then I drink coffee. So I always think of Bobby and how lovely it must be in his world right now, that I'm sitting here in my bedroom with freaking pants on. That's ridiculous. Stupidest thing I ever heard in my life. But I do, because I learned from my mistakes 100%. 1,000%. And I will never get into a business with someone I shared a jail cell with. Yeah, I did. I remember the time I came in the door when my mic was on, and I was like, look at all these effing cats. Because I had a lot of cats at that point. I found homes for a large number of cats in a short period of time. It was hard. It was a nightmare. But you should have pants on, Smurf. That's a good thing. That's a good thing. As far as I know, Linus and Bobby are the only two who aren't wearing pants right now. Bobby, because he said so. Linus, because that's what I'm imagining. All right. BTS. I don't know what BTS is. Maybe I should. British television system. Bull blank shit. Bull total. BTS. You're not wearing pants? Are you wearing a skirt? I always yell at my daughter, but she yells right back. Me and my daughter are like this. Oh, behind the scenes. I knew that. You know. Again, it's a live stream. It's hard to think in a live stream. All right, I don't want to stop, but we do. I'm not carrying my mic with me. Listen, as much as you heard me swear, that's nothing. Absolutely nothing to how I am in real life. Because I just don't find those words offensive anymore. I just don't find those words offensive. I find them natural. It is natural. Now, I worked in a press room. I worked in a garage, working on cars. I worked in a kitchen for many years. The only time there was not a lot of swearing in my work environment was when I was a computer programmer. We had different words for swear words, like technical, nerdy, geeky words for swear words. But everywhere else in my life, it's just a natural flow of conversation. And it's sort of weird when you don't swear in that situation. It's just sort of awkward and weird. So, yes, you get auto-Karen'd a lot, Smurf. Why don't you clean up your language a little bit? No swearing. I know a lot of women my age and a little older are like, they don't swear, but I don't find that as a, like a positive trait or an upstanding trait, because when they, even though they don't swear, they say bad things in a nice way, which is bad. Yeah. I can't swear here because I don't want YouTube. Well, it doesn't really matter. YouTube showed me to 282 people. I could say whatever I want. It's not going to make a difference. But I don't swear because I want it to be comfortable for people who don't swear. You don't have to swear. You can swear as long as it's comfortable for both people. So that's why I think Monica's a sailor too. I think she has a potty mouth. Nan does not have a potty mouth. And that's fine. She doesn't want to have a potty mouth. That's fine. We know Eileen does not have a potty mouth. Period. And don't anybody suggest it. Nobody would suggest it, Eileen. I got your back. And, Bren, he has a potty mouth. But he gets to swear in Australian. So he gets to say things we don't even know. I'm not disrespecting Monica by saying she has a potty mouth. How is that disrespectful? I would be disrespecting Monica if I said she doesn't swear. Then she'd be like, what? I'm cool. I'm cool. Hell yeah, I'm cool. See? It's just the way, you grew up. As long as you don't... See, Granny, that's how I am. I do not care anymore. I do not care what looks nice. I do not care. I just don't care. I do not care. You could and I could teach you some words because I live right beside Philly. I mean, you want to talk about swearing. I would venture to say Philadelphia is worse than New York City. I mean, they just are. Philly is no joke, guys. It's just no joke. There are places even I won't go in Philadelphia. And I would be fine, maybe. I don't know. Really, I don't know. But, all right. See, okay, nowadays kids swear, but again, when a younger person drops an F-bomb, it doesn't mean what it used to mean. It doesn't have the same weight. It's not as offensive. It's a natural word to them. Hell, damn, they're natural words. They are not offensive. So, by the time your great-grandchildren are talking, these are just going to be allowed words. They just are. Yeah, Monica has a potty mouth. But, that's because it's not really that bad. And, nope, not going to say that. I almost went down a road that would have been just terrible. After everything that happened in chat today, going down that road specifically would have been a bad idea. filter in place. Yeah, the F word could mean 100 different things depending on how and when you say it. And sometimes it's lovely. Sometimes it's a lovely word. Absolutely. Okay, and other people, Linus, will find that specific word outstandingly offensive, even worse than the F word. I don't know. I don't get it. I don't know. Yes, you are. Should we desensitize you? I was honorary Australian for one stream, like last week. Remember that? Guys, we've been here. Oh, sugar. I kept you guys so long. I'm so sorry. I just didn't want to stop. I'm so sorry. Yeah, that's a great question. Hold on. I mean, what do you say when you stub your toe? Because, listen, when I stub my toe, swear words fly out of my mouth. A lot. It's specifically that activity. You know, if I bump my elbow, if I hit my knee, if I fall down the steps because of a cat, swear words don't fly. But when I stub my toe, oh my gosh. Oh my goodness gracious. How can you stub your toe and not swear? You should go stub your toe and see what happens. I want to know what you say. See, that's my mom in me. Because when my kids were little, it was, oh gosh, oh sugar. Sugar. That word came out a lot. That did. I tried not to swear in front of my kids when they were little. Now. Exactly. Oof. Oof. That's a good one, Smurf. All right. Thank you so much for coming out. I appreciate it. I do. Today is Tuesday. That means tomorrow we have 2 streams, right? Wait. What is today? Is today Wednesday? Today's Wednesday. We have a stream tonight. Yes, sir. I'm going to put some Judge Fleischer on since Smurf reminded me I forgot to do it during this stream. I'll get some Judge Fleischer for tonight. All right? You guys, I hope you guys have a great day. And I will see you all again in a couple hours. All right? Bye, guys. Thank you.
Yeah.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. So what